see well, my time was finished 1 minute ago. I thank you very much. So please give me a possibility to divide with you some general remarks. The first thesis of my speech, I think most important, is that I would like to thank my colleagues from Central European Academy, Janos, Katarzyna, Balint, for organizing this conference, this beautiful, very fruitful conference, and for the opportunity to speak and to join with you a few theses from my article. The second thesis of my current speech, I think less important, is that European Union has a legal obligation to respect fundamental rights in all areas of integration, and therefore also in the field of common security and defense policy. This simply and seemingly obvious conclusion raises a number of further questions. I think the most important question is a question about legal basis of this obligation, and the second question is about the extent of this obligation, especially on whom this obligation actually rests. Is it a state, maybe only European Union's bodies, or maybe the third state which can participate in EU military operation? And I would like to focus only on these two questions. European Union, unlike member states and third countries which can participate in EU military operation, is not bound by any international agreements in the field on human rights. Hence, according to me, the sources of this obligation should be sought primarily in intra-EU regulation. And I would like to point here the two key provisions. It means, namely, Article 2 and Article 6.3. According to Article 2, the Union is founded on the values of, among other, respect for human rights, and Article 2 lists respect for human rights among the so-called EU values. And Article 6.3, which emphasizes that the EU is bound by fundamental rights, and Article 6 identifies two main sources of fundamental rights. It means the Charter of the fundamental rights and so-called general principles of law. It follows from the Charter that the obligation to respect fundamental rights lies not only with the EU, but also with the member state. However, the scope of this obligation is not the same for the EU and for the member state. The EU is bound by fundamental rights whenever it exercises its competences, regardless of the nature of those competences and regardless of the bodies which act and which legally act. When it comes to member state, according to Article 51 of Charter of Fundamental Rights, member states are only obliged to respect fundamental rights under the Charter when they apply European Union law. According to current judgments of the Court of Justice of European Union, this obligation means that fundamental rights apply to all situations governed by EU law, but not outside such situation. It is extremely important for my speech because member state can participate in EU military operation, and member states are bound by Charter of Fundamental Rights in a situation in which they implement a council decision on a basis of which military operation is established. I'm sorry. On the other hand, a member state is bound by another international instrument, international agreement concerning human rights. Especially, I would like to emphasize the European Convention on Human Rights. It means that human rights obligations incumbent on member states and the European Union are or can be different. And from this point of view, it is very important to ensure that the human rights obligations incumbent on member state and the European Union should have the same scope, and thus that the fundamental rights under the Charter should have the same scope as fundamental rights under other international agreements binding for the states. This harmonization of fundamental rights standards is served by several mechanisms. Now I would like to focus only on two mechanisms. The first mechanism is about interpretation of fundamental rights under the Charter, and the second mechanism is connected with the treaty obligation for the European Union to accede to the European Convention on Human Rights. According to the first mechanism, and according to Article 52 of the Charter of Fundamental Rights, the meaning and scope of the fundamental rights guaranteed by the Charter and the European Convention on Human Rights are the same. But much more interesting is the second mechanism. The second mechanism is connected with the accession of EU to the European Convention on Human Rights. According to Article 6.2, European Union is obliged to accede to European Convention on Human Rights, but with a very important reservation that accession to the Convention shall not affect the competences of the Union as defined in the treaties. This means that a future accession should be shaped in such a way that it doesn't not lead to changes in the EU's competences. And implementing the EU's obligation to accede to the European Convention on Human Rights would certainly solve many of the problems associated with EU military missions. But in practice, implementing this obligation in such a way as not to infringe on the Union's competence under the treaties has proved very difficult. Negotiations for the accession agreement have been ongoing since 2010, and it doesn't finish till. During the negotiation, the Court of Justice issued its opinion on 13, which further complicated the negotiation process. And now the most important issue which hasn't been resolved is an issue connected with the jurisprudence of Court of Justice in the area of common foreign and security policy. The Court of Justice competence in the field of common foreign and security policy is in principle excluded, and most of the European Union's acts and actions in the field of common foreign and security policy are not subject to judicial review by the Court of Justice. This primarily concerns acts creating EU military and civilian missions and their actual activities, which may lead to violations of fundamental rights. The discussion in the EU Forum on how to ensure that the Court of Justice has jurisdiction to exercise judicial review over common foreign and security policy, acts and actions, has been ongoing since 2019. During this time, several proposals have emerged to address this issue. The most important proposal imply, firstly, an expansive interpretation of the treaty provisions concerning the Court of Justice jurisdiction, and the second proposal is connected with changing the treaties by way of intergovernmental declaration. These two solutions are not so good because according to the treaties, the jurisdiction of Court of Justice is expressly excluded in the common security and defense policy, and treaties expressly introduce only two exceptions. And it is the reason why the extension of the Court of Justice jurisdiction to new areas of the common security and defense policy should take place through the procedure indicated in Article 48 of Treaty on European Union. But I would like to propose only two another possibilities. First, according to the first the solution, a treaty mechanism according to which we should respect the fundamental rights can be entrusted to the national courts of the member state. And the second possibility is the amendment of the treaty according to the procedure contained in Article 48, and according to this proposal, it is worthy to discuss, to think about repealing the provision obligation the EU to accede to the European Convention on Human Rights. Thank you for your attention.